Start. Having been unsuccessful in his challenge to an order of suspension, comma, the original petitioner is in appeal, full stop. The appellant instituted writ proceedings assailing an order of suspension dated 15 January 2016 passed by the second respondent, full stop. The writ petition has come to be disposed of with the learned single judge holding that considering the allegations recorded in the impugned order, no interference was warranted with the order of suspension, full stop. Noticing the submission of the counsel for the appellant and no charge sheet had been served upon him, the writ petition was disposed of, calling upon the respondents to issue a charge sheet to the appellant within 15 days in case they contemplate holding a departmental inquiry and that the inquiry itself be completed within a period of 2 months, full stop. The judgment rendered by the learned single judge on 10 February 2016 forms subject matter of this appeal, full stop, para. The appellant is a Lekpal attached to the office of the second respondent, full stop. It transpires that a complaint with regard to illegal construction on public utility land was made on 5 January 2016, full stop. This complaint was marked by the second respondent for further compliance to the appellant as the order impugned in the writ petition itself records the complaint dated 5 January 2016 was handed over to the appellant on 12th January 2016, full stop. On 15th January 2016, the second respondent passed an order suspending the appellant, full stop. The order records that despite the complaint having been duly forwarded to the appellant for compliance, no steps had been taken by him, as a result of which the image of the department had been sullied and the second respondent embarrassed before his superior officers. The second respondent proceeded to hold that the appellant was guilty of having conducted himself in violation of the conduct rules and also having failed to abide by directions issued by a superior officer, full stop. On this stage of the record, the second respondent proceeded to suspend the appellant, full stop. In the writ petition, comma, the appellant had averred that upon receipt of the complaint on 12 January 2016, comma, sent a communication to the complainant on 14 January 2016 to be present on site on 18 January 2016 when in his presence further action may be taken, full stop. It was further asserted that on 18th January 2016 a spot inspection was undertaken. Whether a report was submitted by the appellant recording that the encroachment and illegal construction cannot be removed by the consolidation authorities, and that the same would have to be demolished by the tehsil authorities with the aid of police force. Full stop. A report of the spot inspection was duly submitted. Full stop. The appellant further points out that the order of suspension carried two conflicting dates, in as much as while the first page of the order carries a date of 19 January 2016, the last page carries a date of 15 January 2016, full stop. It was lastly submitted that the order of suspension itself had been made in violation of the provisions of Rule 4 of the UP Government's Servants Rules, 1999, full stop, para. In support of this proposition, he relied on Sita Mani versus State of UP, 1986, 4 SCC 447, in which this court has held that the High Court, while exercising its jurisdiction under Articles 226 and 227 of the Constitution, should not interfere with a finding of fact of the inferior court or tribunal except where the finding was perverse and not based on any material evidence or has resulted in manifest injustice. Full stop. He submitted that this court has further taken a view that if the trial court came to a conclusion, the High Court will not disturb the conclusion arrived at by the trial court merely because the High Court is of the view that a different conclusion is also possible on the same evidence. Full stop. He vehemently argued that the High Court has lost sight of these limitations of its jurisdiction and on the basis of its own appraisal of the evidence taken a view that the respondent number 1 was a juvenile on the date of the commission of the offence and has set aside the order of the trial court. Full stop. Over.